Hi, Bill Henshaw here, your walking constitution from the San Francisco Peninsula, and some of the best news I've had in a long time. And it comes from how I conduct my life. And a wise man once said that talent hits a target no one else can hit. Genius hits a target that no one else can see. And that's exactly what I have done here. I have, hard paperwork from the district court filed a demand for default summary judgment against a law firm and an attorney for multi-millions of dollars. Who the hell does that? You sure as hell know pro se litigant, which is specifically not what I am, and it's not what you are either. That gets you off to a good start, identifying who the hell it is you are and telling the court why you are where you are jurisdictionally. And that's what I did. And based on a lot of what you might call reading of tea leaves here with the 9 old farts in Washington, D.C., proof you've been following my videos, I've acted like a judicial court for the first time in 90 years. What that means is they're going to have our backs on a lot of our issues when we get there. That hasn't been true. That's been the missing element. And the other side is getting to the point they're taking serious notice of that, especially with the all-out assault on the administrative state by the Supreme Court and now the circuit courts, particularly the Fifth Circuit. That said, I have a narrow window of opportunity for one of you to get involved, maybe more than one. We'll see about that. Because I have a window here, where I'm looking for a serious upgrade in networking and some investment capital. If you can deal with both of those in a serious way, I want to hear from you. Send me an email, youwinnincourt@gmail.com, and I have my portfolio dead, bang, black, and white. And they can't beat me, they can't beat you and me, us, because when we get in there, we're not going to be filtered by a state bar association attorney, and they're going to have to get cross-examined by me in front of a jury if it ever gets that far. And it won't. I've never seen a jury. I'm never going to see one. I'm just too damn good at what I do. And that is the way it is. I spent a lot of time putting all this together, and I have an innate ability, God-given ability to do it and see the perspective. And that's what you will learn from me, and it's what I will teach to juries in short order if I ever get in front of one. Not going to happen. But it's a great opportunity, and not just financially. In fact, for me, the money is secondary. The big deal is with what I've just done here. This sets the record going down the road, and I'm going to be convincing a lot of other perps to get their checkbooks out since I've already done the impossible, and they can't be sure I won't do it to them as well. And that's not good for them, for the system, for the democracy. 3 wolves and 2 sheep voting on what's for dinner. That's what we want to get rid of, get back to our Republican form of government of defined and limited powers. No one's saying it was perfect, but we can go from there and make changes consistent with the Constitution, not in contravention of it. And that's why they can't beat us. You get in front of a jury, yeah, it's going to be a lot of money. Not why we're there. We want to make changes in the way the system works to benefit us, our children, and our posterity, exactly like the framers did. Jurors are going to react to that instinctively and understand. And what do they have on the other side? Ain't a lot of lawyers there dressed up in $2,000 suits, and all they're there for is the money and to save their ass and keep the state bar in business. It's a no-brainer. So that's what I'm offering here, a chance to get involved and do very well in multiple ways. So serious investors, send me an email, youwinnincourt@gmail.com. I've got black and white proof of everything I say. That's how we set an unopposed record in the trial court in this case that I now have the default judgment. 48 pages plus exhibits. The attorney for plaintiff with the sworn duty to prove jurisdiction and venue, didn't even attempt it. The black robe bastard, aka State Bar Association attorney, denied it one word. And I get on the record with witnesses as a private attorney general and demand a factual foundation and legal basis for what he did. Didn't say two words. That beats him. It's going to expose the entirety of the corruption of the state bar. And good riddance. This is the opportunity we have. I've been working for a long time to get this far, and I'm virtually all the way there. I need a little help, as I said, with some networking and with some investment capital, but not as much as you would think, and it can be done on very reasonable terms. Right now with the default, I don't know, how much time will be involved and how long, but the default's there. The guy never showed up, and I've got an order in there for the Article 3 judge to sign. And if he doesn't, and he holds a hearing, now we're going to have a problem, because wait a minute here. If we're on the other side, what do they do to us? 12B6 summary judgment. What's the difference? If he does not sign the order, then we go right straight to the 9 parts in my former hometown of Washington, D.C., and get an order from that court to order him to do his discretionless ministerial duty. And I talked a bit longer here than I should, but in any case, great opportunity, narrow window. If you want to contact me, send me an email, youwinnincourt@gmail.com. I don't say it if I can't prove it. Thank you.